Hello friends, I am Dr. M. Sivaji Rao, Principal of Sri Prasanna College of Law, Kurnool, Andhra Pradesh. Welcome to the sixth part of our constitutional series. In this video, today I am going to explain about the judicial review under Indian Constitution. Please consider subscribing to get notified for more videos on Indian Constitution. In my last video, I had explained about doctrine of judicial review by narrating the famous Marbury versus Madison case decided by the American Supreme Court. So, basing on this case, what we learnt is that judicial review is the absolute power of the judiciary which can strike down any unconstitutional provision of any law. Since the Constitution is fundamental and paramount law of the nation. In Indian Constitution also, this power of judicial review is indirectly mentioned in Article 13. The main object of this Article 13 is to secure the paramount of the Constitution with respect to fundamental rights. This Article 13 restricts the legislative power of the Parliament. Now, I will explain the judicial review laid down in Article 13 of Indian Constitution. Article 13 Clause 1 declares about the fate of the laws which were enacted by the British rulers before independence. This article declares that if any old law contradicts with any of our present fundamental rights, to that extent of inconsistency, the old law is void. Prior to Indian independence, the British government had enacted many laws for India. Most of those laws are in force even now. Regarding this, Article 13 Clause 1 clarifies that so far as the pre-constitution laws which are not inconsistent with our fundamental rights are valid and enforceable. For example, the Indian Penal Code, Indian Contracts Act, Transfer of Property Act, Civil Procedure Code, Criminal Procedure Code and Evidence Act, like that there are many laws have been enacted by the British government for India. But even now also these acts are in force because these acts are not contradicting or not inconsistent with our fundamental rights. Next, coming to Article 13(2), this article says that the state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. So, after independence also, state cannot make any law which violates the fundamental rights. The first clause, that is Article 13(1), relates to pre-constitutional laws, and the second clause, that is Article 13 Clause 2, relates to post-constitutional laws. Through judicial review, the judiciary shall interfere in the following circumstances. Number 1. For violation of provisions of Constitution by the state. Second, for violation of doctrine of distribution of powers. Under our Constitution, powers are distributed between center and states. If center encroaches any powers of the state or vice versa, then the judiciary can interfere. Third one, any legislative act which delegates the excessive power to the executive. In doctrine of delegated legislation, the legislature can delegate or transfer any of its law-making powers to the executive. If this power is excessively delegated, then the judiciary can interfere. Fourth one, for reviewing any ambiguity or for interpretation of any constitutional provisions, judiciary can interfere. For fifth one, for testing the validity of any actions of the state. It means if the state overstepped or acts excessively while enforcing any law, then also the judiciary can interfere. what can be challenged by judicial review? Regarding this question, any aggrieved person or public spirited person or NGOs can challenge by way of filing public interest litigation. What can be challenged? Any actions, inactions and orders of a public authority which are exercising public functions are all potentially challengeable by judicial review. The main grounds for judicial review includes illegality, irrationality, procedural laches, unfairness and incompatibility with the fundamental rights. The judicial review power is a power of the check and balance over the three branches of the federal government, that is legislature, executive and judiciary, in order to limit each other and ensure a balance of power. Next, coming to classifications, judicial review can be classified into three categories. They are: number 1, judicial review of legislative action; number 2, judicial review of administrative action; number 3, judicial review of judicial decisions. First we shall discuss the first classification, that is judicial review of legislative actions. The law enacted by the Parliament and the state legislature must be in harmony with the Indian Constitution. Though the Parliament is empowered to amend the Constitution, it cannot be exercised so as to damage the essential feature of the Constitution or to destroy its basic structure. The Supreme Court and all High Courts shall have the power to review such law. If such law is against the spirit of the Constitution, then that law will be struck down by the judiciary. Now I will explain two landmark judgments on judicial review wherein the Supreme Court has reviewed and overruled the legislative action. The first one is Supreme Court Advocates on Record Association and another versus Union of India. The Parliament has established the National Judicial Appointment Commission, that is NJAC, by amending the Constitution through the 99th Amendment. This National Judicial Appointment Commission would have replaced the existing collegium system for the appointment of judges of Supreme Court and High Courts in India. But on 16th October 2015, the Supreme Court by 4:1 majority struck down the National Judicial Appointment Commission, since it will destroy the independence of the judiciary and thereafter restore the old collegium system. The second case is L. Chandrakumar versus Union of India. In this case, the Parliament bypassed the interference of all courts except Supreme Court over the decisions of the tribunals. The Supreme Court held that all the decisions of the tribunals will be subject to scrutiny by a division bench of the respective high courts within whose jurisdiction the concerned tribunal falls. The Supreme Court said that the Parliament cannot take away the judicial review power of the High Courts over the decisions of the tribunals so as to damage the essential feature of the Constitution or to destroy its basic feature. Next, coming to judicial review and the basic structure. In Kesavananda Bharati versus State of Kerala case, the Supreme Court has propounded the doctrine of basic structure. The court said that the Parliament can amend the Constitution but without changing the basic structure of the Constitution. In Indira Nehru Gandhi versus Rajnarayan case, the Supreme Court for the first time applied the judgment of the landmark case, Kesavananda Bharati case, and held that Clause 4 of Article 329A, which took away the power of the judicial review and destroys the basic structure as such, it is unconstitutional. In Kihito Hollahan versus Judicial case, the Supreme Court held that para 7 of the 10th schedule as unconstitutional since it took away the judicial review power on the matter of disqualification of MLAs and MPs against the decision of Speaker or Chairman. The Supreme Court observed that this para 7 dishonored the basic structure of the Constitution. Second classification is judicial review of administrative action. In this type of judicial review, the judiciary will have power on administrative action also as well. When the power comes into the hands of executive such as administrative agencies, statutory corporations, quasi-judicial authorities, regulatory authorities, etc., they will forget their responsibility and disregard the rights of common people. That is why the judiciary has the power of judicial review over administrative actions. So, the doctrine of judicial review is the interposition of the judicial restraint on the legislative, executive and judicial actions of the government. Through the doctrine of judicial review, which is the basic structure of the Constitution, it is not justified in policy matters. However, it is justified in policy matters provided the policy is arbitrary, unfair, violation of any fundamental rights. In Kerala Bar Hotels Association versus State of Kerala case, the Supreme Court held that the courts must be desist to venture into an evolution of the state policy which must not be a reasonable time to pan out. Another case is Balco Employees Union versus Union of India and others. In this case, the validity of the decision of the Union government to disinvest and transfer 51% shares of its Messrs. Bharat Aluminium Company Limited was challenged. The Supreme Court said that in the case of a policy decision on economic matters, the courts should be very careful in conducting any inquiry or investigation and must be most reluctant to impugn the judgment of the experts who may have arrived at a conclusion unless the court is satisfied that there is illegality in the decision itself. Third classification is judicial review of judicial decision. Judicial review of judicial decision means reviewing the decisions of lower courts by higher courts by way of appeal, review, reference and revision. Generally, all the high courts or higher courts in India have wide range powers of judicial review under statutory and constitutional provisions. This type of judicial review is used to correct or make any change in the earlier decisions of the judiciary itself. But while exercising these powers, the courts must act with utmost care and caution. Further, the Supreme Court has power to review or alter its own earlier decisions. In J.P. Bansal versus State of Rajasthan case, the Supreme Court has examined the impartiality of the judiciary endangers in the community attention. The Supreme Court said that judges should not play the role of lawmakers, but they should exercise judicial thoughts only. So, the fate of laws which are inconsistent with the fundamental rights were decided by the Supreme Court of India by explaining in three important doctrines. These doctrines of doctrine of severability, doctrine of eclipse, doctrine of waiver will be explained in my next video. Okay friends, this is the end of my video. If you have any queries, please post it in the comment section. I will attach the PDF file of this lecture in the description. Thank you very much. God bless you all.